The operating agreement is there as sort of the neutral third party of the minimum standard that we have to abide by. If I buy your gym today and find out 6 months from now that somebody got injured 2 weeks ago and we're only finding out about it 6 months later and I've bought it, I'm now the owner of the LLC. I have to deal with that liability.
Discussing partnerships and
don't do it. Next topic.
Don't discuss them. All right. Hello, everyone, and welcome to another episode of the Cheer Biz Podcast. I'm your host, Dan Cotton, and we are here for the first ever, we've been talking about it for a little bit, in-person episode with Matt Becker. He is now an Oregonian, living in Oregon, and he moved at the perfect time in the summer when it's a total lie, and it's like 90 on a hot day and beautiful, and it's really amazing.
What do you mean? What's going to happen?
You just wait until December when it rains for 5 months straight. It's either raining or it's freezing cold and it's never snowing. So it's...
well, what's your definition of freezing cold?
I mean, below freezing, like 21
All right,
Fahrenheit.
21 gets
Fahrenheit.
a little... Yeah, okay.
The Canadians are like, 21 Celsius, that's not cold. But yeah, it's a good time. I mean, I love it. Lived here my whole life, so...
We've loved it here so far. I think we're now... March to where are we? July?
Yeah, we're in
so
July.
Like 4 months, 5 months. Yeah, we love it. We're having a ton of fun. We're getting out. We're seeing a lot of things. We bought some sup boards. So
okay.
We've been supping over at Sauvie Island.
Okay.
So yeah, we're taking it in. I don't mind the winters. In Pittsburgh, it was like snowed for 2 months straight and would get to like 11 degrees or like negative numbers. So
that sounds miserable.
If you're just like, oh, like 25, I'm like, hey, that's still shorts weather.
Good for you.
But anyway.
Good for you. So I definitely cannot wear shorts in 21 degrees. That's too cold for me. And I live in shorts and sweats all the time. But yeah, so we're here in person, super excited. We were chatting today. One of these days, we'll probably do an episode where we just sit down and talk like we do at conference. And I just hit you with things and then you ask me questions and are like, don't do that.
I don't know the answer.
But today we have a couple things that have come up recently for either gym owners that I've worked with or myself. And we were discussing some different topics that we could talk about. So the first one being discussing partnerships and
don't do it. Next topic.
don't discuss them. So discussing partnerships and what is the right methodology if you're going to do a partnership, how to do that the right way, how to avoid getting stuck in one, because it is very easy to kind of get jammed up. Yeah. And Tori and I actually started with a partner for like 18 months and it went terribly. And it went 18 months. Yeah, exactly. And there was a very contentious rift after about 13 months that ended in a separation. Yeah. And we were, in hindsight, we had no contracts. It was just, we're going to do this thing together.
Right.
And then,
which is how most of them start.
Yeah. And then we ended up with we had to do a buyout and all this stuff. And we're like,
buyout price.
And we were the kind of people who were like, well, his name wasn't even on anything except emails and things saying, and statements of owners, right? Yep. But it was nothing legal,
right?
And we didn't make any money. The first year we just lost money, and we were like, well, they didn't put in any money financially. Like, why would they get money out? And we learned some painful lesson. Now, we got out for really, really cheap. Like, I'll be honest, it was not a ton of money. But if someone is in the position where they're looking at doing this with a partner, or maybe they already have a partner, but they never did put anything on paper, right? What should they be doing to set themselves up for success?
Yeah. I laugh at partnerships. It's not necessarily meant like if you do, there are successful partnerships out there. It is possible, right? Just as there are successful marriages out there. So it is possible. Just know that like just as many partnerships dissolve as marriages get divorced. And so you have to go into it with that thought in mind. Like two people come together, like we're best friends. We want to start a gym regardless of the type of gym that we're talking about. And then they're like, let's just do this because we're never going to have any problems. We're bros or, we're sisters, whatever. We're going to make all this money. And they just proceed forward kind of like you guys did, thinking nothing is ever going to happen here. Just as technically we want to go into a marriage not thinking that we're ever going to get divorced. But we all know that the majority of marriages end in divorce. The majority of partnerships end in some sort of dissolution. So the best thing you can do is treat it formally like you didn't know this person at all. And you didn't necessarily trust this person at all. And what do we then need to do from the legal side in order to protect against the really strong potential inevitability that we're going to have a problem down the road? This is 9 times out of 10 going to come in whenever we talk about money. So who's making the money? How's the money being earned? Who's getting paid for what? Like all these cause massive partnership problems. So really to get down to the sort of the crux of your question is whenever we form a partnership, there are technically sort of like 3 different types of legal entities. There are partnership legal entities, and then there's corporations and limited liability companies. When we're talking partnerships, we're not forming a legal partnership. I can explain why if you want me to, but we're actually forming either a corporation or a limited liability company. Corporations are too formal, so we're just going to put those off to the side. We're going to form a limited liability company between the 2 or 3 or 4 people. And the governing document is called the multi-member operating agreement. We've talked about it on the show before. And in that document, if you're going to have a partnership, we need to be so specific as to take away as much discretion as we possibly can if there's going to be a problem. So for your example, you guys got down the road, something happened by which we realized the partnership wasn't going to exist anymore. We needed to get out. You had no agreement to explain, how do we get out? How do we price this thing? How do we buy out? Under what conditions can we buy out? Can we force people out? These are all problems that come up weekly for us with talking to partnerships that we could have headed off had we got there in the beginning. And I had that conversation with them to say, do you want the ability to kick your partner out? Because we can put that into an operating agreement under certain conditions. And they'll go, no. Literally a year later, they'll call back and be like, I need to get my partner out of here. Well,
you said you didn't want
about it. You said you didn't want the ability to kick them out. Now they're doing exactly what was predicted that they were or not going to do, but we can't push them out because we don't have anything in writing.
So what are things that people should be looking to put into writing from a contractual standpoint? And can they do this retroactively? If they have a partnership right now, can they go, you know what? Oopsie, didn't do this. Let's do it now.
You can always go back and fix the problem before there's a problem. So if I need to kick you out now, there's no way I'm going to get you to agree to an operating agreement that is going to explain how we're going to value the LLC so I know how to pay you out of your 50%. But if we catch it before it happens, we can always go back and put these documents in place. So money is going to be the biggest factor. Whenever we're talking about like, well, what do we put in an operating agreement? Well, what are we going to do with money? How are the partners going to be paid? How often are we going to pay the partners? How do we determine which partner makes what money from what job that they're doing? Or is it just going to be like a complete 50-50 split? So that's sort of like big factor number one is how are we going to deal with money? Because that's going to head off a lot of the later stuff. From there, you want to talk about like what happens if your husband and wife, which is a lot of partnerships we deal with, what happens if there's a dissolution of the marriage? Do we want to wait and just fight over that in divorce court? Or can we put in the operating agreement what automatically triggers if there's a divorce amongst the marriage? So we can head off that problem. We then want to talk about like, what are the rights to buy out your other person? If everybody agrees and you just want to leave, then I get the right of first refusal as your partner to buy your interest. How are we going to value that? We're not going to wait and figure that out because we're going to be butting heads when you want to make a lot of money and I want to pay you as little as possible. So in the operating agreement, we're going to say, if there's ever a valuation on the company, these are the valuation methods that we're going to use. So we take that factor out of it. What happens if a partner dies? You don't want to deal with the estate to try to buy your 50%. We can set prices. Like there's a million different little rabbit holes and things that we can go down here. A big one in our industry is this ability to kick a partner out. And the way that this typically comes up is you and I start and we're like, yeah, we're going to build this awesome gym. And then because you exist as a company, you're educating gym owners to realize it's not that easy from day one to making $1 million. About a year in, there's typically that one partner that's like, this wasn't as fun as I thought it was going to be. This actually is a lot of work. Wow, Dan really does make this look a lot easier than it really is to run and own a gym. And they stop doing anything. They go back to their full-time job. They go hit the sup board every day. They're not doing their social media posts. They're not coaching their classes. You're now paying another coach to have to sub in for them.
Right.
And you call me and say, I need to get my partner out of here. They're not doing anything. In the legal terms, that's called a call right. You are allowed to go around to the other members of the LLC and call their interest back if they're not doing their job. And so that's the biggest one that we recommend to gym owners is you guys come up with a job description every year. As long as the partners are maintaining that job description, you can't do anything. They're working in the business.
Right.
But if they screw off and they're not doing their job, if they're not coaching the 20 classes that they're supposed to be coaching a week, if they're not posting 5 times to social media, you give them a warning. And if they still don't continue to do anything, you then have the right to say, okay, under the operating agreement, I'm forcing a buyout. And we already know how much it's going to cost. We already know what the payment plan is going to be. Either fix your stuff or get out of here. I'm buying you out.
Okay. And how should one... This is a broad question, so you're probably going to say, I already know the answer, everyone. It depends. But how does one go about determining this amount for a buyout?
Okay. So we're going to use a valuation method. There are numerous different valuation methods. Okay. A common one that everybody likes to throw around is called EBITDA, interest before... Darn it. It was right there.
Tax.
Earnings before interest, taxation, depreciation, and amortization.
Yeah.
Or you can have EBIT. You can have seller's discretionary earnings. You can have liquidation. So these are just different ways of valuing a business. The problem is most people either don't understand the valuations or they just listen to the industry and they just apply an EBITDA valuation to their, and accountants love EBITDA because it's like super easy. Once they've been doing your book so many years, they can just like click a button and give you an EBITDA valuation. So that's like one way of determining it is just saying, we'll just go to our accountant and we'll figure out whatever the valuation is. And so then it comes and it says, well, okay, the value of your gym is $200,000. You and I are 50-50 owners. So I got to come up with $100,000 in order to buy you out. That's the typically the easiest way to do it. The problem with EBITDA is that really EBITDA is only great valuation method if the business is exceeding about $2 million in revenue and $1 million in some sort of net owner benefit or payout, and it's not owner operated. So a lot of your gyms get to a point where you guys replace yourselves with directors, you replace yourself with general managers, and so EBITDA could come in as a really good valuation method, but 9 times out of 10, until you hit those marks, you're really just going to run with some sort of discretionary earnings valuation. Anyway, most
cheer gyms, just factually speaking, are not to that $2 million in revenue, anywhere near $1 million in net benefit. I don't know of any gyms. I mean, they might exist, but I don't know of any cheer gyms that anyone is doing $1 million in net benefit for the ownership.
I haven't seen it in cheer. We see it in gymnastics. Yeah. But we have not seen it in cheer.
Yeah.
I at least have.
I haven't seen it in cheer. I know there are gyms doing more than $2 million in gross, but I don't know about truly netting $1 million. I'll let you know. Maybe I can be the first. Goals.
Yes. Manifest it.
Yeah. Okay. So what is a discretionary earnings then? What does that look like?
Yeah. So discretionary earnings is going to be primarily whatever you pay yourself from the business. It could be what you pay yourself as a salary. It could be what you're paying yourself as a bonus or an owner draw or distribution from the company. And then there's going to be a series of what we call add backs. Okay. So if you look at a standard P&L, you're going to see a whole bunch of, a profit and loss document. Yeah. Okay. You're going to see a whole bunch of expenses. You'll see cost of goods sold, you'll see labor, and then you might see things like rent, utilities, services, and then you might see things in there like medical insurance, vehicle, cell phone. These are all expenses that benefit you personally as the owner, but that you run through the company for typically tax purposes, right? Those are what are considered add backs, because if I come in and I buy your business, I may or may not have the business pay for my vehicle.
Right.
So if you're spending $1,500 a month on, insurance and vehicles and everything else, and you sell me the gym, that could be $1,500 a month immediately going into my pocket because I already have my car paid for.
Mm-hmm.
So those are called add backs. So through a whole valuation process, we're going to do all of the math, add back every benefit that you receive from the business that won't necessarily pass on to the new owner. And we get this one number that is essentially considered your seller's discretionary earnings.
Okay.
And that's essentially how much you make or is there for you to make from the business.
So I hear you saying it's just a really easy, quick, simple math calculation.
It is plug and play. Plug and play, baby.
No problem. Take a couple minutes and
Yeah. A couple minutes times about like 50.
If you don't know those things, like let's say you're that gym that hasn't been paying attention to their numbers, you don't go through an accountant and get really solid P&Ls.
Yep.
You're just kind of doing everything yourself.
Yep.
But you're in that position this is basically was me, right? I was like, I don't know, like we have QuickBooks, but it's not very accurate.
Right.
From what it looks like, we didn't make anything. We didn't pay ourselves anything. And like the first year was brutal. And we still had to come up with some sort of evaluation. I think we just came up with an offer.
And that's sort of the opposite side of this that I'll get to, but continue.
Yeah. So like I guess the answer would be figure out your numbers and track those things.
Yeah. And I know that like you guys as mentors probably beat your head against the table sometimes trying to get gym owners to understand their numbers, get their books put together, get their financials organized. And these are just some of the reasons that from our perspective, we want to see organized financials. You guys obviously want to see it because you got to figure out like, what can we cut? What can we add? How do we increase a net owner benefit on the back end here? So if your books are just completely disorganized, you can still get to a rough valuation because chances are your taxes, if somebody's filing a tax return, there's some organization to the tax return that we can pull numbers from. But the alternative here that we're to kind of bring this back around to like, how do we do this within a partnership agreement is we can set a valuation, or we can pick just what's called a set price. And so a set price is literally, regardless of how well the gym is doing, regardless of how much money we're making, this is the set price. So we can set a set price for lots of different factors within an operating agreement in order to try to head some of this off if it ever becomes a problem. So we might say something like, if I have to kick you out because you're not doing your work, then we're going to value the LLC at a set price of $50,000. So I only owe you $25,000 if you're a 50% owner in order to get out of the LLC.
Okay.
Or if you die and the LLC is worth $1 million and I got to come up with $500,000 in order to buy your 50% interest, we might agree that a set price of $200,000 is what would happen if we needed a death buyout.
Okay.
So we can set all of these. There's pros and cons. Obviously, a con to that is if the business does really well and you're leaving, you want more money than that set price. But these are ways that we can try to take some of this guessing game out so that we avoid a situation similar to what you ended up with, where it was like, what's this thing worth? Does it have any value? Do I owe you any money? And then at the end of the day, the operating agreement is there as sort of the neutral third party of the minimum standard that we have to abide by. Even if the operating agreement says we have to appraise this thing and you and I just agree that I'm going to give you $50,000, then we just go into an agreement on that. We don't have to worry about what the operating agreement says.
So when we started this whole conversation and, how to avoid getting stuck in partnerships, your tongue-in-cheek response was, don't do that.
Don't do it to begin with.
And I know you kind of mentioned that similar to divorce, there is a high frequency. Why is that kind of your knee-jerk reaction of just avoid partnerships? And what have you seen as the most common reasons for partnership dissolution?
Mm-hmm. Yeah, so I harken back to my days as a litigator when I used to sue car dealerships for crappy cars, a lot of used car dealerships for used cars and used car problems. So I will never buy a used car because nobody ever called my law firm and was like, hey, let me tell you about this awesome used car I bought. It was just always, let me talk about this piece of crap that I bought. And for doing this the better part of a decade, I just developed this opinion that like, don't buy a used car. Don't go to used car dealership. Don't buy a used car. So it kind of happens that way with partnerships too. Nobody calls me to tell me about their successful partnership. People only call me in order to tell me about their crappy partnership. So you just kind of develop this
callous,
right?
Yeah.
The stereotype that like partnerships, they're ultimately going to fail. And then to answer the second question, the number one issue that's going to impact your partnership is going to be money. Who's being paid what? How much is somebody owed? Or, as I've said, you've stopped working in the business and I now have to keep paying you 50% under because you're 50% owner.
Right.
And at the end of the month, we've got $10,000 profit. You're going to want your $5,000, even though you're not doing anything for it.
Yeah. That's probably, I would say, one of the more common ones I've seen is either the money side of it or engagement. And you kind of mentioned it before, like, well, you're not doing anything.
Right.
Like you're retired on duty kind of attitude of, but you're still an owner, but I'm having to do all the work and you're just reaping benefit. And we never agreed to that.
Yeah. So to do it successfully, you got to put as much down in writing as you possibly can so that it's like any other contract, right? We put as much expectation within that contract as we possibly can. So that at the end of the day, we at least have something we can shake in the partner's face to say, like, this is what we agreed to. This is our legally binding agreement. I don't want to go get attorneys involved. So let's try to figure this out before that happens, because otherwise I'm going to sue you for a breach of the operating agreement.
Right.
Which we never want to get to that point.
And you would suggest doing this on the front end of the partnership. So like essentially before you even open, right?
Ideally.
Like once we form the company.
That's right.
We create this document.
That's right.
And set these rules.
Ideally at the beginning. Yes, to your point, we can go back and do it now if a listener doesn't have it. It's perfectly fine. I'm working with a company in Texas right now. They've been in business for probably about 10 to 15 years. They have they're a corporation, so they need a shareholders agreement, but they don't have one. But they know they're getting older in their age. The gym's probably going to sell it sometime here in the near future. And it's like, yes, great. Now let's get a shareholder. Like, we're going to go back and retroactively do this, just so that there are clear terms about how do we get to a point of selling, how do we agree on price, et cetera.
Yeah. And that's, and full transparency, obviously, I have a partnership. Next Generation Gym Owners is a partnership. And when I came on as an owner, I had to sign a whole bunch of documentation of all of this, you know, what my ownership percentage was and what dissolution looks like and just all of those different things, what it takes to get an owner out and how we do the valuation if we're in that position. I remember being like, wow, this is a lot of freaking paperwork. And I'm going, I should have done this the first time I did a partnership. Would you suggest doing that though? You mentioned a lot of people, me and Tori included, they go into partnerships with their spouse. And you're suggesting that even if you're doing this with someone you're married to, you should still have this detailed out, almost prenup wise. I know a lot of people get married without a prenup. I know I did. Yeah. But lack of doing this in a business, even with your spouse, is risky.
Yeah. I mean, statutorily, every LLC has to have an operating agreement. Every corporation has to have shareholder agreements, potentially bylaws, depending on what state you're in. So by the letter of the law, you have to have one anyway, regardless of whether you're a sole owner, you have multiple partners, you're with your spouse, whatever it is. And so from that point, we might as well go through all of this stuff in preparation, because we don't know. I didn't get married to think 9 years later I'd get a divorce.
Right.
And you may have been married 20 years. You may have been married 50 years. Unfortunately, we all have that couple somewhere in our life that we're like, oh, wow, I never thought they would get divorced. So crap happens. We might as well try to put in some plans, because whether or not that's a marital asset depends on when it was created, depends on what state you're in, depends on a whole bunch of different factors. If we can come to an agreement now to say, like, in the event of divorce, my wife's, maybe she's the one who's really running the gym. I'll agree to sell her my 50% at this valuation. That's going to be super easy now in a divorce proceeding, because we're going to be like, well, we've already taken care of that asset.
Yeah. So recently I had talked to a client, and I think I sent them your way actually, who is in the process of buying their gym from basically the owner who's in place. They're a coach. And actually, again, this is what Tori and I did. We were coaches in the gym. We approached our gym owner with an offer to buy them. What should people be aware of when trying to go down
The buying path?
The buying path.
Yeah.
And, should each side have their own attorney? Who should draft up what contracts? Like, give me a breakdown. If it was you or you were advising a client, these are the steps you should take if you want to buy an already existing business and set yourself up for success.
Yep. Okay. So before we even start talking about buying, there's two different types of sales we can have. There's a stock sale and there's an asset sale. Stock sale is literally you're selling the entire legal entity, either the corporation or the LLC. In this industry, we typically don't do that because if I come in and I buy, is it an LLC you have with Tori? I don't know.
Yes, it is.
I thought so, but I couldn't remember.
I mean, you made my operating agreement, but it's fine.
That's fine.
It was 2 years ago.
So the bottom line is I could come in and I could buy 100% of your LLC. That's a stock sale. The problem is there's a statute of limitations on personal injury. It's usually 2 to 3 years, depending on what state you're in. If I buy your gym today and find out 6 months from now that somebody got injured 2 weeks ago and we're only finding out about it 6 months later and I've bought it, I'm now the owner of the LLC. I have to deal with that liability. So there's what we call a tail of liability post-sale, essentially equivalent to the statute of limitations for personal injury in your state after your closing date. There are ways we can protect against this, but in this industry, we don't like that. So we typically just do an asset sale. An asset sale, as the word would imply, I'm only buying your assets. So I'm coming in and I'm just buying essentially all of your tangible equipment, everything in this room, everything out in that giant room you have out there with all your mats and everything else. That's all your tangible equipment. And then we have two primary intangible assets, one of which is your client list, and the other one, or your accounts receivable, basically. And the other one is your branding. If there's any brand power to what you guys have. You guys love your brand power, so there's a lot of value to that.
Yeah.
So that's the first thing what we have to determine is, do we want to do this as a stock sale or an asset sale? Usually we're going to do it as an asset sale. From there, the next thing to do is to approach the owner. And you basically say, hey, look, I'd love to walk down a conversation of buying your gym. Is that something that you would be willing to consider? Assuming that the owner says no, then we're done. If the owner says yes, then the owner should at that point ask you to sign a non-disclosure agreement. And that basically says that we're going to go into a path where you're going to show me financials for the next step. And once you don't want me looking at those financials and then going and talking to everybody else, or looking at your client list if I don't already have access to it, and then going and soliciting all of those clients because I'm going to go open my own gym. And these are things that like people might think we're a little bit paranoid about, but it happens. So therefore we have to protect against it. All right. So I've signed the NDA now as the potential buyer. Next, I got to figure out what is this thing even worth? And that's where these valuations now come into play. I will say as a caveat on this, valuations in this particular portion of the industry, I do the brokerage for adult fitness industries, third level consulting with Frank. They do brokerage for child activity centers. We're essentially partners in brokerage. He gets all child activity centers. I get all adult activity centers. So I can talk about all of this, but honestly, if you want a valuation of your gym, if you're thinking about selling your gym, I'm going to push you over to third level anyway. Okay. And he does that for us on the adult stuff. So you get the valuation done. We're both going to give you very comprehensive 8 different method valuations that is going to give you a very clear picture of what that gym that you're potentially buying is worth. If you think you can then afford it, you're going to present the owner with a letter of intent to purchase the assets. This is sort of like the formal kickoff of, okay, we're doing this. You then enter formal due diligence, which is really just, it gives you, the buyer, the opportunity to you can ask for pretty much anything you want in order to support. If you think the gym's worth $200,000, you're going to buy it for $200,000. You've done some due diligence pre-LOI in order to determine, is this even worth diving into? You've determined that it is. Now is your right to see anything. You can dive into P&Ls, dive into the lease agreement, social media accounts, all other assets, bank accounts if you're doing a stock sale. You can look at all of these different things in order to finally determine, yes, indeed, I want to buy this gym. At which point you as the buyer are technically supposed to present the purchase paperwork to the seller. Again, in the fitness industry, our smaller gyms like this, I would say less than about $750,000. It doesn't always equate that way because sometimes we're selling to a coach and the coach doesn't necessarily have a ton of money to go hire an attorney. So oftentimes the seller will foot the bill for the attorney stuff, which is where we can come in both industries. Draft paperwork, both sides agree, and then ultimately you get to the closing where you buy everything. So that's very broad, sort of the buying and selling process.
Yeah.
But that's sort of like the 8 to 10 steps that you go through.
Yeah. And if you're already in that position, you've already started a purchase process, or you maybe even already bought the gym without buying the gym, and you need to get some actual legal documentation together, because, correct me if I'm wrong, a handshake, I sold you the gym, is not super legally binding and potentially could create challenges in the future for that person.
It definitely can create some challenges. It is technically a legally binding handshake, but good luck proving it, and good luck proving the terms of the buyout.
Right. And those are like, I think I remember when we did our purchase, there was a lot of discussion of what responsibilities became our responsibilities, because there was outstanding debt for the company. And there were certain things that we said part of the buyout was like, okay, we'll take care of those. Like, we'll take care of, I think they had outstanding like property tax stuff that they hadn't paid. We're like, we'll pay that, but you have to pay X, Y, and Z that you accrued. And we are not accepting any other debts that come up, even if they come up 10 years from now, someone comes collecting, not on us, even though we bought the company from you, which paid off because we actually had something like that happen 10 years later. Yeah,
that's called an indemnification clause. There's lots of different things we can do with an indemnification clause, but that basically says if something pops up after this that you didn't tell me about before we closed, you have to come indemnify and hold me harmless from that issue. So that was very good that you guys had that.
It was great. We did have an attorney help us with drafting up all the paperwork, though. We did know we're going to pay for this one.
Yeah.
So you mentioned, as a pivot, it works perfectly. You mentioned if you buy a gym and you don't have some of the reasons you might not want to buy it in the stock sale is if there were an injury or something that occurred and you didn't know about it, and that person then comes back to sue the company and you bought all the stock. So with injuries, I've run a cheer gym long enough, kids get hurt. I mean, it is just a reality. Your kids are flipping through the air. Things happen, all the way from basic sprains and small minor issues to breaks to significant ligament tears. I mean, those things are all very possible. And unfortunately, I would hate to say normal, but expected. I mean, I've seen a lot of dislocated joints and torn ACLs. And when I say a lot, I mean, more than 2.
Yeah.
You do it long enough, you're going to see injuries. I actually recently had reached out to you because I had an injury at one of my events, one of my camps, where an athlete hurt their ankle through no fault. I mean, it's just normal tumbling.
I've rolled 2 ankles in 2 weeks running in the woods. It just happens.
Yeah, it does, right? It's supposed to land on your feet flat, and unfortunately didn't, and ankle rolled pretty severely. And so we had a conversation about what were the right steps. So what do you recommend as the steps someone should follow when there is an injury in the gym? Assuming you've got your waivers, because if you don't,
that's a problem.
Call Matt. Simple.
We need to do waivers.
Yeah, just do a waiver. Assuming you got your waivers in place and you got that in place, like what should be the steps?
Let's go through some steps here. So immediately prior to ever having an injury, you need some kind of operating procedure that designates to your staff what happens in the event of an injury. If you're going to be there every day, every hour that the gym is open, fine. Like, I won't push you on the operating procedure because you know what's going to happen in the event of an injury. But you're not always going to be there. You have coaches and directors and general managers and things for a reason. So make sure you have some kind of procedure that says if there's an event of an injury, and we've written up emergency action plans for gyms before, this is what happens. All right. From there, injury goes down. Then somebody should be contacting the owner if you're not there immediately. And everybody needs to start observing what's happening, having your emergency action plan that hopefully the staff member does not say, oh my gosh, I'm so sorry that happened. Because that can come back to haunt you if somebody's paying attention to that, because by apologizing, a plaintiff's attorney is going to argue you just admitted that you were at fault in some way. Right. So these are like, I know that everybody's like freaking out. The kid's on the ground. They're possibly crying. Somebody's potentially going to say something, but we need to educate our staff ahead of time of like, really try not to do that. We're just going to assess the situation. We're going to support the injury or whatever. We're going to call 911. We don't provide any medical advice or any medical services whatsoever. That should be outlined in your waiver. We're just going to call 911. I even, in my gym, I owned a gym for 11 years. I had a guy go down with a heart attack at one point during a workout. He even tried to tell me, don't call an ambulance. I said, okay. I started my timer and I said, you got 5 minutes. If you don't improve in 5 minutes, I'm calling an ambulance. 3 minutes later, I called the ambulance because he was not improving. And he was all but unconscious. So I was like, I don't care at this point. Yeah. So I called the ambulance. They got him to the hospital in time. He arrested 13 times while I was at the hospital. Thankfully, he lived because we got him to the hospital in time. So I don't care what the kid says or what the parent says. You call an ambulance. Okay, it's your business. Immediately after the situation is resolved, you get as many staff members as was there to write you an incident report. This needs to be a written incident report, not told to you, texted, okay, fine. But ideally, we've got some sort of who, what, when, where, why, either paper or outline that we want everybody to fill out. We want to do it as immediately as possible because we don't want time to pass and for memories to start to fade or cloud or anything else. From there, the next question is really like, do we immediately call our insurance company? There's a fine line between calling our insurance company, and this is not ever going to become an issue, versus not calling the insurance company. And then later it does become an issue and you've just given your insurance company the opportunity to deny your claim because you didn't inform them of the problem. Generally speaking, within 24, 48 hours, we're going to recommend the gym owner calls the insurance company just to put them on notice. Next, gym owner needs to go pull a copy of that liability waiver. That's always like one of those butt clenching phone calls that we get of like, this happened. Do you have a waiver? It doesn't look like we have one signed. Okay, that's a problem because you just gave your insurance company the next reason to deny your claim because you don't have a signed liability waiver. So once we kind of have those steps completed, and again, at no point are we saying to the parents or to the child, to the client, to whoever, I'm so sorry that happened, or we'll make this right, or I'm going to talk to the coach to find out what we could have done better. Whatever you feel inclined in order to try to make the parent or the kid feel better, just try not to do it. Because we're trying not to set yourself up. I even told you, I was like, don't, if you want to give them a credit, if you want to give them a refund, fine. But don't say something like, I'm really sorry this happened. We'd love to have her back next year. If you'd like to have her come, here's a refund of your money. Just don't do it. You can provide a credit. You can provide a refund. In my very strict world, I'm going to say, if we do that, we want a release of claims from the client, from the parent to say, I'm going to give you a refund. You're going to agree not to sue me on this. And so there's that's sometimes a little bit to the extreme. Yeah. But get it documented.
Yeah, you said that and it like instantly gave me the uncomfy feeling of like, is this just gonna stir the pot more to reach out and be like, hey, so I know you asked if we do refunds if you miss a certain portion because you got hurt while you were here.
Right.
And again, I'm not admitting any sort of fault. Like, your athlete was tumbling and rolled their ankle. I'm not going to apologize. Like, it's not my fault.
Yep,
that happened.
Not your fault.
Gravity exists and we challenge it in our sport. And sometimes things happen. But being like, yeah, I'll give you a refund if you sign this thing, I sometimes feels like almost more of a, I know I did something wrong and I'm letting you know like, hey, I think I maybe did something. So sign this thing and I'll pay you.
The nice thing is that if they refuse to pay and then sue you, they can't use that offer of settlement as an admission of guilt.
Oh, okay.
So that's helpful.
You mentioned calling an ambulance as like the default and providing we're not providing any sort of medical attention or assessment or anything and just calling an ambulance. At what level? Because I mean, maybe I'm way out of line on this, but I look at things all the time and I go, hey, I think you could go to the doctor and get checked if you really want to, but looks like you rolled your ankle. It's swelling up. We're going to have some ice. Parents, it's up to you, kind of your decision. I wouldn't call an ambulance for that. Typically speaking, if I did, I'd have to call a lot of ambulances. They would love my business because I would make them a lot of money.
I think that's fair.
So are you saying calling ambulances, like, I guess I'm trying to determine what is, from your perspective, the right approach. Because I've called an ambulance twice in my gym. And we've had, I mean, even kids that I've been like, they may have just torn their ACL. Like when I was playing sports in high school, we didn't call an ambulance for that. It was just, hey, something happened. They're stabilized. You need to go see a doctor.
Yeah. And I do think there's some judgment call there. You back me into a corner as an attorney and you know, it's like, well, yeah, but there was that one time that they didn't call an ambulance and they walked the kid out and they tore their ACL even worse. And then the gym got sued because they didn't call an ambulance to pick him up. But does that mean every time a kid sprains their shoulder, every time the kid rolls their ankle and we can put some ice on it and like 10 minutes later the kid is fine, we should have called an ambulance? No, I agree with you. That's probably taking it a little bit to an extreme. Head injuries, call an ambulance. If they're bleeding excessively, which probably doesn't really happen that much, but if they're bleeding excessively, call an ambulance. Again, not so much in this industry because most kids probably aren't having heart attacks. But if you have adults, or if you're in an industry where you're dealing with adults, and it seems like, because I mean, when my guy went down with a heart attack, it was like 95 degrees at the end of May, and it was like no clouds in the sky. So we're just like, maybe you got really dehydrated. It was after like 45 minutes into a workout. So there's some question about like, is there a judgment call here of like, maybe we just need to give them some water because they're dehydrated? And that was another reason I was like, I'm going to give you 5 minutes. Like, you add some water. If you don't look like you're improving, I'm going to the extreme of calling an ambulance because I'm not going to have a guy die on my floor. So I think you're okay with some judgment calls of determining whether or not, like, even if you call the parent's like, I'll come pick them up. Okay. If they just have a torn ACL or a rolled ankle or something, that's not life-threatening. You don't have to call an ambulance in that instance. So I think you're fine pushing back.
That's where we default a lot to, is like, hey, if you think there's an injury and it's going to need you should be calling parents, right? And see where you want to go. Because I've had parents that I've called and I've been like, hey, their arm's broken. Like, there's no question it's an S shape and it's not supposed to be an S shape. And
she has an elbow above her elbow.
Yeah, we put a splint on it and like it's immobilized like you would do a standard first aid training, which we all have. So basic first aid principles, get them comfortable, and then do you want us to call an ambulance? Are you right here? Do you want to take them to the hospital yourself? Because ambulances are expensive, right? And I come with the law enforcement side of like, you don't need to be in an ambulance for 90% of the stuff that they put. Heart attack, yes, right? Something like that, please be in an ambulance. But whether I ride to a hospital with my arm in a splint in my mom's car or in a $900 ambulance ride for 4 miles. So that's been, I guess, our default. So I heard you say that and I was like, okay, might need to change our policies and procedures a little bit. It's interesting. So you also mentioned, which all of us do, right? Like, we say, oh, I'm so sorry. Like, most of the time we're just what people are trying to say is like, I'm sorry you're hurt.
Yeah.
Like, because I am sorry that you're hurt. I don't want anyone to be hurt, even if it's their own fault. Like, I watched, videos of people killing themselves on TikTok with some bike and like landing on their head, and obviously not killing themselves, but like, landing, and I'm like, oh, I'm sorry for them. Like, that looks like it hurts.
Right.
Not an admission of guilt.
Right.
I had nothing to do with it. So how should we train our staff to respond? Like, are they supposed to just be robots and be like, you are injured? I am making no statements.
Still.
I think of it like the Rohr's admonishment. Like, nothing I'm going to say is going to communicate my thoughts, beliefs, or state of mind. Like, just so you know, anything I say, it's not my actual thoughts, beliefs, no admission of guilt here.
Well, I think training your staff to do this is going to be very challenging to do, because you're right. We're all, for the most part, empathetic humans. And if somebody gets injured, we're all also probably responsible business owners. So we feel this like duty to take responsibility if something happens. And all I'm saying is you're giving a plaintiff's attorney a lot of ammunition if they can reproduce that statement in some way. So saying something like, I'm sorry you got injured, that's probably, not that big of a deal, because you're not saying, I'm sorry you got injured because our floor was raised, or I'm sorry my coach didn't spot you and now you have a rolled ankle. So you can probably get away with just expressing some sorrow for the injury as opposed to what happened in order for them to get injured.
Right. Okay. So saying, like, I might say something like, man, I just hate that you got hurt. Like, just never want to see an athlete get hurt tumbling. It's just,
right.
that's just a flat out true statement.
Right.
Not saying I did anything wrong or my staff or my equipment, because I think it is really hard. Like, what do you, it's hard to be in that moment and go, okay, I can't say anything nice.
But, I'll listen to gym owners and they'll say things like, oh, yeah, well, I just told the client, like, I'm so sorry this happened to you. Please let us know what the medical bills are.
Oh, yeah. That's crazy.
No, don't say that. Don't say that.
Yeah. Yeah.
If you get a letter from an attorney that says, here's the medical bills, we'll deal with that. But make no statements about, let us know how much it costs, or, we're so sorry this happened in just a couple days into camp. Like, we'll make sure that we refund you this year.
Right.
No.
I'm a much bigger believer of like, keep me posted because I'll be thinking about you.
Yeah.
I'd love to know how it turns out.
Exactly.
Kind of thing.
That's perfect.
Because I do just want to know. And I honestly, most of the time it's because I do honestly just care. And I'm like worried, especially when I don't know what the issue is. Obviously, S-shaped arm kid. I know it's broken, but I still want to know, like, are you going to have surgery? Are you like, are they going to reset it? Like, what's
we have to get somebody else on the team?
Yeah. All the things you have to think about. But yeah, that's very interesting. And I know I've heard staff say those kind of things before.
Yeah, we all understand why they do it. But, also you did put in a step in there that I didn't in this industry, call the parents. I didn't put that step in there initially because, we don't always deal with this exact industry.
Right.
But yeah, call the parents. And also if you have cameras, go ahead and make sure that you somehow reserve that camera footage. If your cameras cycle every 24 hours or something like that, and you have the ability to save like that little snippet, save it, because that can help a lot.
Because it at least is showing what actually happened. Yeah, the imagery of what happened.
Yeah.
What if you have cameras, but the camera didn't pick up the injury?
I mean, if it's not on the cameras, then
should you still retain that time block?
Yeah, great point. Yeah, I would say so. Yeah, I mean, if there's no camera in the room, obviously there's no ability. But if there was a camera up there in that corner, and all of a sudden, when push comes to shove, you're going to claim that we didn't get recorded this entire time.
I'm also thinking just like it's sometimes hard to get every angle, right? And so, or you have an angle, but where the injury happened was just off of camera. At that point in time, my thought would be, hey, we should still retain all of the video from that time spot of when the injury occurred, just so someone can't come back and say, well, it's on camera and they deleted it.
Right.
Exactly. They're hiding the information. Yep. We'd call it abstaining. Right. It's the whole, where is the 1 minute of footage kind of thing. And if you at least have it all retained and you can say, look, here it is, like, this is everything.
Yeah, this is every angle. They went here, they're off camera.
Yeah.
We don't know what happened.
I think that would be my recommendation, but I'm not an attorney. So anything else when it comes to injuries that people should be prepared? You mentioned refunds a little bit. What would be appropriate? Like, someone gets hurt day one of class. Is it inappropriate to refund them for the rest of the month? Say, hey, you only came to one class. You're not going to be able to attend the rest of them. So here's a refund. Is that an admission of guilt?
I think it depends on what you say around the refund. Kind of like when we've been talking about, like, what do you say around the time in which they get injured? I mean, from a purely business perspective, I'm going to say, like, I'm not giving a refund until they ask for it, especially if it wasn't my fault.
Right.
But if you do want to give a refund, if they ask for it, if you just want to give them a refund out of the kindness of their own heart, say something neutral like you just said. Like, hey, I understand you only got to come for one day of our program. Here's a refund. Go ahead, or I'll give you a credit if you want to come back again next year or something like that. Use it for some neutral reason like that, other than, I'm so sorry that you got injured in our facility on the first day of the program. I know my coach feels really bad. Here's your refund. So it just depends on what you're going to say around it. And you can, I think to your point, you can be empathetic without admitting too much.
Right. Because I would, like, let's say someone came to a class, had their very first tumbling class, just didn't like it. Was like, we're not going to keep going. We hated that. I'd probably be like, no stress. I'll give you your money back. Like, and so I hate to, on the flip side, be like, oh, you got hurt? I'm still charging you. And it wasn't 30 days prior to the renewal, so I'm charging you for next month too. Which we all know we can't do anymore, but I hope so. If you didn't, go back and listen to that episode.
Yeah. Well, actually, for the click to cancel,
yeah,
it's done. You didn't hear?
Oh, no.
Oh, yeah.
Oh, give us an update.
Oh, wow. Okay. Breaking news. Last week, a federal court kicked it out on procedural issues. They said the FTC didn't follow proper procedure and do some sort of research analysis on the impact of the rule. And so the appeals court kicked it out. Said, if you're going to do this, you have to go back and redo this research.
Wow. So click to cancel is done.
Cancel's done.
So you can still maintain your trials and your...
In most states.
In most states.
Yeah.
Most states.
Yeah, there's still state individual click to cancels that are enforceable.
Okay.
But from the federal stuff, what we've been freaking out about and talking about and lecturing about since January, don't have to worry about it anymore on the federal level.
Okay. So
right now.
States that need to worry about it, California, New York, Oregon,
there's
liberal.
I think Ohio. Iowa. And then there's one in the middle that I can never remember. It's like Montana, Minnesota, Wisconsin, somewhere in there. If you're in any of those states, just reach out to me. I'll tell you exactly whether or not it's you. They just implemented over the last year a pretty strict click to cancel rule. But you hit the other ones pretty good. California is the biggest.
Yeah, and I'm going to just soapbox for 2 seconds from a business perspective. Although it may have been kicked out on a procedural rule, I think a lot of it came from the perspective of doing right by a customer. And I think there are a few, they maybe went a little too far on some things, but generally speaking, you're just asking for chargebacks and a whole bunch of issues if you go, sorry, you canceled at 25 days and you're supposed to cancel at 30 days. I'm charging you for the next month.
Yep.
And I don't know about anyone else. I'm not winning chargebacks right now. Yeah. Even with contracts, even with everything, they're just like, no, sorry.
Yeah.
Like it's just not.
I had one gym recently reach out and said they won a chargeback using one of the contracts we wrote, but that is very rare. And I would love to think it's because of the contract that I wrote.
It is because of gymlawyers.com. You can get your contracts that are chargeback proof.
I'd love to think that was it, but maybe it was just a factor. But yeah, chargebacks, if you're trying to punish, I think we've talked about this before. So if you're trying to punish the client, I mean, like you said, it's just not the best business practices. You're gonna create more headaches for yourself than it's worth.
Yeah. Yeah.
All right.
Well, we've gone for almost an hour.
Yeah.
Which is normal for us. You had mentioned common insurance gaps.
Sure.
I feel like that one's pretty quick.
Yeah. I mean, since we're talking about injury already.
Yeah.
There are two types of liability that we expose ourselves to in most of the gym industries that you and I are concerned about, and that's instructor-led and open gym. There's general liability, there's professional liability. General liability is what you're exposed to if you have open gym. Just like I walked into your facility and I was exposed to general liability. I could have tripped over something. I could have.
By the way, you didn't sign a waiver, so I'm going to need you to leave.
I just knocked and some woman let me in. So that's general liability. Professional liability is anytime we're telling somebody what to do, which is also like 90% of our business. I come in, you tell me how to do a back handspring. I break my ankle. I believe it's because you told me to do the back handspring. I sue you. That's professional liability. All right. On this basic level, our insurance policy, assuming that we are doing at least, like, even if we don't have open gym, your facility still has general liability. If you're offering anything instructor-led, anything coach-led, anything in which somebody is telling somebody else what to do, you have to have professional liability. For the majority of the run-of-the-mill commercial insurance policies we see, it only has general liability. It does not cover professional liability, which means if I come in and you tell me to do a back handspring and I hurt my ankle and I sue you and you don't have professional liability coverage, you don't have insurance coverage. So you're going to take the brunt of that claim without any insurance. So we have to make sure that the insurance policy is actually covering what you're doing. Other common holes are usually underfunded or undercapped molestation policies, abuse and molestation, which again, unfortunately is big in this industry in gymnastics. So a lot of the policies we see maybe have like $10,000, $30,000 limits, and that's not going to cover you. It's not going to cover you. We need to make sure that we have both kids and parents. Occasionally we'll come across one in this industry that doesn't cover kids. And we're like, how did the broker get away with selling you this? It doesn't even, not only does it not have professional coverage, but it doesn't even cover kids. Usually in this industry, we're not going outside too much, but if you ever take your people outside of your facility, you want to make sure that you have, or you do not have, a designated premises exclusion. So you can call your broker and say, do I have a designated premises exclusion? If you do, once you leave the four walls of your facility, you are no longer covered. So again, you guys might go to like a park every once in a while or something. Yeah. My background in CrossFit, it's every other day we're sending people outside to run.
Right.
So those are big gaps.
We do too. Our kids go run around the building.
Oh, they do?
Yeah, absolutely.
Yeah. Okay. So you need to make sure that you're covered once your kids go outside the four walls of your facility. So those are some of the big ones that we see a lot of times, especially with that professional versus general liability coverage. Yeah. Like Hartford policies, State Farm policies, these common, just like State Farm covers my home, so I'm just going to call them to get my business too. Be careful, because it doesn't necessarily mean that you're covered for the activities that you're doing. I've even seen policies owned or paid for by a gym that specifically says exercise and fitness instruction is excluded from this policy. It's buried on like page 98 of the 150-page policy.
Perfect. Yeah. Okay.
You got to come through these things. And of course, the gym owner's not going to come through these things because there's not enough coffee in the world for a gym owner to drink to get through one of these things. So you just got to make sure you're covered.
Okay. Quick question on that. Professional liability. What if you have 1099 contractors? Are they going to be covered under professional liability? 9
times out of 10, we don't want our contractors covered under our policies, period. Your insurance may. There are insurance policies out there that will cover contractors, but we don't want it to, because remember, there's all this swinging pendulum with independent contractors versus employees. And a bright line rule is if you provide your staff benefits, they're automatically an employee. I think I'm talking to Danielle about this sometime soon too in the fireside chat. Hey, quick promo. Can I do that on your show? Because she's like,
sure, she would love that. Because I have more listeners.
For now.
Exactly.
So if we're providing like medical benefits, that's obvious, right? Like,
sure,
we just provided medical insurance. Obviously, they now need to be an employee.
Right.
What we overlook is like, well, what happens if one of my contractors are in the gym and a kid gets hurt and the contractor gets pulled into the lawsuit because they were the ones who did it? You're going to get put into the lawsuit because you're the gym. And then you're going to call your insurance policy and say, hey, my contractor got sued, pull him in under my policy. You just provided them a benefit. So now you've just opened up that can of worms that we can now go back. Somebody, workers' comp, unemployment, your State Department of Labor may catch wind of this and now all of a sudden be like, wait a second, you just provide them a benefit. You've been providing them that potential benefit all along. They're an employee. How long have you been paying them as a contractor? So we're going to fine you for misclassification. And then we want you to do all of their federal matches for the last 5 years that you've been treating them improperly as a contractor.
And now you're broke.
Yep. And now you're broke because that cost you $40,000.
Yeah. Yay, bankruptcy.
Yeah. So don't give your contractors insurance. They need their own policies.
Okay.
Which they can get for like $350 a year. So
okay.
Not terrible.
Okay. Interesting. All right. Well, with that, listen to the Fireside Chat episode that will be coming out at some point. Well, thank you, Matt, for joining us. And I'm sorry, those of you who are watching, I'll try and get more technologically advanced, because if you're watching this on YouTube, you're just staring at the sides of our faces.
Oh, yeah.
You're denied our beautiful front.
Should we dance now so that like you can put in there, watch till the end?
No.
Of course, they could just fast forward.
We definitely shouldn't. And they get to, I'm wearing a tank top today, so it's a win. I'm going to totally get in trouble. Danielle hates when I wear tank tops, but it's what I wear during camp season. So yeah, everyone, thank you for joining us for the first in-person interview with Matt Becker. Hopefully you enjoyed it. Yes, we were waiting for this. And we will do another one sometime soon.